Hello, and welcome to the Masters Showcase, a Masters Conference series. The Masters Showcase is a series of recordings of discussions with industry leaders within the legal community. We will be getting started with today's chat in just a moment, but before we begin, just a few program details. My name is Kevin Clark, and I will be the host of the Masters Showcase. Please note that the views expressed by all parties on the Masters Showcase belong solely to the participants themselves and do not represent the views or opinions of their organizations. And now to get started with today's Masters Showcase. So today's guest is a partner from Sidley Austin and is out of Washington, D.C. I've known him and his family for many years and have had the pleasure of working with him on multiple cases, as well as within various organizations. Welcome, Robert. Welcome to the Masters Showcase.
Thank you, Kevin. Really appreciate you having me here.
So to start off with, we're going to throw you a softball. Where are you from, Robert?
Oh, I'm from Richmond, Virginia, originally, but I've been in the DC area now for 20 years, ever since I came from law school.
Okay, and you have a family? I know your family, so tell me a little about your family.
I do. I have 3 boys, which keep me very busy, particularly now during the quarantine era. And I have a wonderful wife who's also a lawyer, who was at Skadden Arps for a number of years as an associate before taking a much harder job with staying home with our children.
Excellent. And where did you go to undergrad, Robert?
I went to a school called James Madison University in Virginia, and then went to University of Virginia for law school.
And what brought you to ediscovery? How did you end up in this area?
Well, I think for a lot of folks in our generation, I have a similar experience where I got into ediscovery by accident. So one of my first cases, if not my first case at Sidley, just to date myself a little bit, the company had email, but they had just adopted it, and storage back then was so expensive that the company actually would print out their emails and file them. So you can imagine companies doing that today. But it wasn't long though with probably my second or third case. I was kind of by coincidence staffed on the Sidley DC office's first case that involved a backup restoration and review. And it was kind of like one of our first cases that involved kind of like a larger data population, a larger review team. And I got staffed on that. And then from that point forward, I was kind of known as the person who had experience on the big case, right? And so when other larger matters with larger data sets would come in, I would get brought onto those. And so as a result, I kind of developed an experience over time with these larger matters, all of which kind of by necessity involved ediscovery, or at least the early forms of ediscovery back then, which is, for us, was really the only way to do it, because when I went to law school, there was no such thing as ediscovery. So that's kind of, it was more organic over the years, where I tended to more and more specialize and focus on ediscovery as I got further along in my career.
Okay, excellent. And would you consider yourself a technologist?
I would probably not consider myself a technologist. I would consider myself kind of a consumer of technology, if that makes sense. So in my position at Sidley, as I said, as co-chair of the ediscovery task force at Sidley, I get brought into a large number of matters. Many of those matters, the vendor and the platform have already been chosen. So I get a pretty broad experience to lots of different types of technology in the ediscovery space, both on the for all aspects and all phases of the EDRM, from collection to review and analysis and the like. And so that has given me a pretty wide breadth of experience on different types of technology. But I'm not, let's say, a computer coder or anything like that, or have that kind of background. But it's more seeing practically how these applications can impact matters, both litigation and investigatory matters.
And now you mentioned you're the co-chair of your ediscovery practice. How big is your ediscovery practice at Sidley?
So we at Sidley have a pretty focused team. We have me and my co-chair, Colleen Kenny, who's out of our Chicago office. Then we have two ediscovery counsel, Matt Jackson and Eli Nelson, and then a number of associates who focus on it, as well as several staff attorneys who assist as well.
Okay. And how long have you all had a ediscovery practice and had a specific group that focuses on this area?
The task force itself, was formed, I want to say approximately about 15 years ago. And it was kind of developed to first identify issues for the firm and help kind of develop expertise. And it's kind of grown over time to its current state.
Mm-hmm. Okay. Now, what are some key areas, some key discovery challenges facing law firms that you're seeing and corporations, maybe your clients and within law firms? What kind of issues have you been seeing out there?
So it's a good question. I would say, the biggest challenge relates to kind of what's known in common parlance in the ediscovery world as the 4 V's. So this refers to, otherwise known as volume, variety, velocity, and veracity. So, just to break those down, volume is just the ever increasing volume of data. Variety is what it sounds like, and is perhaps one of the greatest challenges, which is the different kinds of data, the different data types, including different data sources, where data is coming from. Veracity is basically the uncertainty of data, and particularly with streaming data or information governance issues, where you might not even know where your data lies or where it might be. And then velocity, I guess, is the more the streaming of the data and how that data changes over time. This is kind of not a new issue. As I said, this has been around for a number of years, but the fact that it keeps increasing, so the volume, the variety of data keeps increasing, is posing an increasing challenge to the traditional ways that litigants handle data sets, right? So 10 years ago, if you collected somebody's email and user files off their laptop, and back then particularly maybe their thumb drives or the like, you could be pretty confident that you have captured 95%, if not 100% of their custodial data. Now, that may be correct, that may be still true, and it may be you've captured 30% of their data, right? It's just how that person conducts business. and they can conduct business entirely on their mobile device or their tablet. They could be using all different kinds of applications, including structured data applications. They could be using different types of apps to conduct business, or having relevant information on either the app or some kind of social media platform. And so that creates a big challenge for continuing to use kind of traditional approaches to that data, either for collection or for review and analysis. And so I think that is what we're facing as far as kind of the biggest challenge, and you need really better and more sophisticated approaches to confront and handle the increasing volume and variety of data.
Do you see the technologies we currently have today is being able to take on these challenges?
So I think that technology is getting better at it, but there's still, we still have kind of holes in our ability to really process certain types of data and analyze certain data. So like voice is a continuing issue, video is a continuing issue about how to really efficiently review and analyze those data sources. Structured data is a challenge depending upon the type of data. And then of course, social media or messaging applications and the like, there are solutions out there, but they're not at the same place as the solutions that allow you to review and analyze kind of traditional unstructured email data and the like.
Right. And where do you see ediscovery going in the future?
So I think the biggest challenge here is that ediscovery is only going to get more complex. So first off, it's now occupying the field, right? So because the vast majority of people and companies are digital, all discovery now is ediscovery. And so that has important ramifications for how both litigations and investigations are conducted, where you can no longer kind of cabin kind of the ediscovery piece off to one side and have kind of the traditional discovery proceed. The kind of the issues underlying ediscovery now are impacting all parts of the discovery lifecycle. And with kind of the increasing variety and complexity of how people communicate, that raises increasing challenges to kind of ediscovery and really being able on a bottom level, being able to do kind of two things. One, comply kind of with the technical discovery requests. So like the discovery requests or your CIDs or your subpoenas, being able to comply with those. But two, more importantly, to be able to find the evidence in your case, to find what matters. And as the volume and variety of data increases, it becomes harder to find the needles in the haystack, because the number of needles is basically remaining the same, but we have a lot more hay. And so trying to identify the evidence within kind of identify the signal amidst increasing noise is really the singular challenge, I think, facing ediscovery going forward.
Right. Now, it seems to be there's been a merger lately of ediscovery with some other areas that relate to data, information governance. You see a lot of privacy, cybersecurity. Have you seen that in your practice and in what you're seeing in the industry? And do you think there's going to be a merger of these data related practices?
Yes, I'm certainly seeing that. And if not a merger, I think we will see increasing overlap between kind of traditional e-discovery and privacy. So for example, we have a dedicated privacy group at Sidley, and I work frequently with them on kind of a range of issues because there is overlap. Identifying or analyzing a breach, for example, oftentimes you leverage kind of the more sophisticated e-discovery tools, right, to assist you with that. But it goes the other way as well. Like I recently published an article in the Sedona Conference Journal about the burden of privacy and discovery. And basically the thesis is that privacy interests and protecting privacy interests can be a burden, a quote unquote burden under Rule 26 that can implicate the proportionality analysis. So in other words, you could have a discovery request that in one matter does not implicate privacy and is proportional. But you could have then the exact same discovery request and have a different matter that does implicate privacy interests. And because of that, would be not proportional under Rule 26. And so I think courts and litigants will be kind of facing this issue in a kind of an increasing amount as time goes on, as kind of the privacy interests are really become more and more a part of these both discovery requests and reviews and productions.
That's an interesting take on the relationship. What was that law school article again?
Yeah,
just extra plug for it because that
yes.
actually sounds really interesting.
It's in the it's called The Burden of Privacy and Discovery, and it was published in the Sedona Conference Journal.
Okay, Sedona. Okay, excellent. Okay, that sounds really interesting. So thank you.
Yeah, thanks.
Now, do you, for jumping to your advice for law students and young practitioners that are coming up through law firms, whatnot, what's some advice that you give them for the younger generation that's coming out of law school or that's just been practicing for a few years?
So I guess two things. One, I interview a fair amount on law school campuses. And one of the biggest questions I get from the law students during the course of the interviews is asking about, how much Sidley, quote unquote, leanly staffs their cases. And the assumption underlying that is that the junior associate will get more, quote unquote, real world experience from a leanly staffed case. And what I tell them is that may be true, but it may not. And most of my experience as an associate came from larger matters involving larger teams, just because there was a lot more opportunity from those larger matters, whether it's depositions or witness interviews or hearings or the like. And so there's a lot more opportunities present. And so think about that and just don't think about kind of the cliches that you're getting from law school about being scared away from your bigger matters. And then the other thing that I tell kind of junior associates at Sidley along the same lines is really embrace the document review, the privilege review side of matters, because that is one of the best ways to get actual experience and improve your judgment as to what actually matters in a case. It's very hard to kind of understand attorney-client privilege in the abstract. What you really need to understand privilege is to go through a privilege review and to help with logging and go through a logging exercise, as maybe painful as that may be to some folks. But that is really the best way to understand how attorney-client privilege actually, what it actually means and how it actually impacts litigation, and how protecting that privilege actually works in the real world. And really the only way to kind of gain that understanding and your judgment as to where the lines are is actually to do that in a case.
Some wise advice. I think many associates do not enjoy or do not see any value in doc review and in priv review. And I think those are some good points. It's actually important for them to do and to learn, and they can actually grow out of it. Besides the bonus of the loss of billable hours a lot of times. But yeah, so this is good advice. Thank you. Well, how has your practice changed due to the COVID-19 virus?
Well, I think like everyone, I have the issue of working from home, right? And the challenges associated with that, with 3 boys running around is always a challenge. I think, when dealing with larger matters and larger teams, there's obviously a coordination issue there, where typically I work in big groups, and so there's some efficiency lost where you're not able to have everybody in a room together and hash out issues. Probably the biggest challenge, I think, is depositions, frankly, and defending depositions remotely and helping to prepare your witness remotely. The technology is good but not great on remote depositions, and it's just not quite the same as being able to be there in person. So that's probably the biggest challenge that I've faced so far. But obviously it's a challenge for everybody to go through this.
Right. No, definitely. I agree about the children. In fact, I'm glad we can talk so early this morning because mine are still sleeping. So you're not seeing in the background running around yelling and screaming.
Right.
So you mentioned depositions. Have you learned any tips or tricks about how to successfully use Zoom or WebEx or GoToMeeting, do a virtual deposition that you can share?
Well, I think the biggest challenge is, how do you do documents? Mm-hmm. Right. And so the success, the most success I've seen is being able to share the documents ahead of time. That makes the deposition go smoothly, or as smooth as it can be. It's a lot harder to try and recreate the traditional deposition cadence, where you're handing over one document at a time, and it's the first time that the witness is seeing that document. That is awkward to do over video. It's much more efficient to share the document ahead of time. But the other broader challenge is just kind of the block and tackling, right? So think about how lighting and your background and the like, and thinking about how that may be seen by the trier of fact, a year from now, is something to consider.
Right. Good points. I know it's a challenge for many of us. Just it's so different. It's changed the entire way that we do depositions.
Yeah.
So, do you see the practice of law changing at all in the long term due to the this pandemic?
I think it probably will have to, and I think probably in a couple of ways. I mean, one, I can see both law firms and companies becoming more comfortable with remote review, remote contract attorney review, particularly in higher cost jurisdictions, where it could really entail significant cost savings. Now we've been forced to do it, but I think a lot of people are seeing how that can be done successfully. and while still maintaining client confidentiality and security. So that's one thing that I think may come out of this. I think also you may see with law firms that an increasing number of attorneys see that they can work remotely, and you may see more of that after this, where people work more remotely than they otherwise would. And then who knows, we could see an increasing drift towards, if that continues, increasing drift towards platooning of office space, like our consultant brethren do. That I think, just a year or two ago, I would have said, would never happen at a law firm. But I could see if more and more people adopt kind of a remote working style, that becomes a efficient solution to cut down on real estate costs.
Right. Excellent. Good points. Good points. So, any final words of wisdom, last thoughts you'd like to share?
Well, that's a good question. I think only my last thought is, I think in the e-discovery world, we often observe that the e-discovery practitioners live in our own bubble. And what that means is, when you go to kind of conferences and the like, it's kind of you see a lot of the familiar faces. And so we're learning from each other and we're helping to teach each other. But I think the biggest challenge and opportunity is to go out and continue to convey lessons and expertise to litigants and white collar practitioners who do not have kind of e-discovery as a focus, and be able to continue to instruct and teach those folks about how to bring kind of the more efficient and effective techniques kind of in the e-discovery world into kind of the day-to-day litigation and white collar matters.
Nice. Excellent. Well, some wise advice. Thank you very much, Robert. Thank you for joining us on the Master Showcase. And we really appreciate you taking the time and sharing your thoughts. So thank you very much.
Yeah, thank you again for having me. I really appreciate it.
Hey, take care, everybody.